In this lecture, we shall discuss committal proceedings. We shall discuss committal proceedings as far as the criminal procedure in Ghana is concerned. Now, students of criminal procedure as well as legal practitioners will be very familiar with the term committal proceedings. Now, by way of an introduction, committal proceedings is a procedure we resort to when an offense is specified by an enactment to be tried on indictment. The only court that has jurisdiction to try an offense on indictment is the High Court. But before the High Court begins with the trial on indictment, the law provides that there must be a preliminary hearing at the district court. And that preliminary hearing at the district court that will be conducted is what we refer to as the committal proceedings. Some of you may have noticed that offenses like murder, you will know that the district court does not have jurisdiction to try the offense of murder. But when somebody has committed the offense of murder, some proceedings happen at the district court. Those proceedings are what we refer to as the committal proceedings. And so, to give a very clear introduction and insights as to what we mean by committal proceedings, I would refer to the dictum of a learned author who has authored a very instructive book on criminal procedure in Ghana. And I will entreat everybody listening to this lecture as much as possible to get a copy of this book, because it simplifies the provisions and the criminal procedure in Ghana. And this book I'm referring to is the book titled Criminal Procedure and Practice in Ghana, authored by Dennis Dominic Ajay. So here's Justice Dennis Dominic Ajay. And so try and then get this book. And if you get this book titled Criminal Procedure and Practice in Ghana, authored by Justice Dennis Dominic Ajay, take a look at page 309. And the statement over there gives a clear insight as to what we mean by committal proceedings in Ghana. And this is what the learned author says at page 309 of his book. Preliminary hearing by district courts in an indictable offense precedes an indictable trial by the High Court. The power to entertain committal proceedings is exclusively vested in a district court. The offenses which committal proceedings are conducted by the district courts are offenses punishable by death, such as murder, and offenses declared by an enactment to be a first-degree felony, unless the law provides that such offenses may be tried summarily. Although the offense of robbery is a first-degree offense, the Enabling Enactment, Criminal Code Amendment Act of 2003, Act 646, which amended Section 149 of Act 29, provides that the Attorney General shall in all cases determine whether the offense of robbery shall be tried summarily or on indictment. The other offenses punishable by death include murder, criminalized under section 46 of verse 29, genocide, criminalized by section 49A of Act 29, treason and high treason, criminalized by section 180 of Act 29, and smuggling of gold or diamond, section 317A of Act 29. The first degree offenses include manslaughter, criminalized by section 50 of Act 29, rape, criminalized by section 97 of Act 29, misprision of treason, criminalized by section 181 of Act 29, treason felony, criminalized by section 182 of Act 29, and piracy, contrary to section 193 of Act 29. Now, why is this dictum of the learned justice important? He proceeds as follows. Why is this dictum of the learned justice important? We are being told at page 309 that, first of all, the preliminary hearing must only be conducted in respect of an indictable offense. We are also told that this preliminary hearing, what we refer to as committal proceedings, it precedes an indictable trial by the High Court. We are further told that the power to entertain committal proceedings is not vested in any court, but it is vested in only the district courts. So at least he gives an indication that it is the district court that has exclusive jurisdiction when it comes to this preliminary hearing referred to as committal proceedings. Not only that, he gives us examples of offenses that may be tried on indictment, because it is only indictable offenses that we will conduct committal proceedings in respect of. And so, he goes ahead to tell us that the offenses which committal proceedings are conducted by the district court are offenses punishable by death, such as murder, and offenses declared by an enactment to be a first degree felony, unless the law provides that such offenses may be tried summarily. This statement contains a very crucial information. It means that offenses that are punishable by death, such as murder, are supposed to be tried on indictment, meaning that we are supposed to have committal proceedings in respect of that one. Then also, offenses that have been declared to be a first degree felony generally are supposed to be tried on indictment, unless the law that criminalizes that first degree felony, unless that law provides that the offense may be tried summarily. What this means is that it is not every offense that is a first degree felony that may be tried on indictment. There are some offenses that, even though are first degree felonies, the law that enacted that criminalized that offense has given an exception that you can try that offense to summarily. That's what he means by saying that the offenses which committal proceedings are conducted by the district courts are offenses punishable by death, such as murder, and offenses declared by an enactment to be a first degree felony, unless the law provides that such offenses may be tried summarily. In other words, there can be some first degree felonies that, even though they are first degree felonies, the law will provide that they can be tried summarily. Then the learned author goes ahead to give an example. That although the offense of robbery is a first degree offense, the enabling enactment, the Criminal Code Amendment Act 2003, Act 646, which amended section 149 of Act 29, provides that the Attorney General shall in all cases determine whether the offense of robbery shall be tried summarily on indictment. Meaning that even though robbery is a first degree felony, the law has given a possibility of trying robbery, even though a first degree felony, by a summary trial. So it is important to note that capital offenses like murder are triable on indictment. First degree felonies are also triable on indictment, but the law that creates that first degree felony, check it and find out whether it also gives a possibility of trying that offense summarily, as we have for the offense of robbery. The learned author goes ahead to give specific examples of offenses that are punishable by death. He mentions murder, genocide, treason and high treason, and smuggling of gold or diamond. Then he mentions first degree offenses. That these first degree offenses include manslaughter, rape, misprising of treason, treason felony, and piracy. So if you are supposed to narrate the procedure for trying a person for the offense of manslaughter, because you know that it's a first degree felony, you know that it's an offense that is supposed to be tried on indictment. If it's an offense that is supposed to be tried on indictment, then it means that you must first go to the district court to conduct what we call the committal proceedings. So this is by way of introduction, to let you know that the language committal proceedings is used when we have an offense we are supposed to try on indictment at the High Court. But before you begin a trial at the High Court, you must conduct your committal proceedings at the district court. Why do I say this? If you look at section 181 of the Criminal and Other Offences Procedure Act of 1960 at 30, which is the applicable law in Ghana, it reads as follows, and I quote: a criminal case for trial on indictment shall not be brought before the High Court unless it has been previously brought before a district court and the accused person has been committed for trial to the High Court. End of quote. What this means is that even though it is the High Court that has jurisdiction to trial indictments, you shall not bring that case before the High Court unless that case has been previously brought before a district court for the accused person to be committed for trial to the High Court. How do we kickstart the proceedings? If you are the prosecutor, you are the Attorney General, and you are of the view that someone has committed an indictable offense, what is the first thing that you will do? There's something we call a bill of indictment and summary of evidence. The bill of indictment is what will state the charge against the accused person. The summary of evidence will comprise the list of witnesses that the prosecution intends to call at the trial and the list of documents that they propose to put in evidence at the trial. So if you are of the view that someone has committed a capital offense, murder, before you bring him to the High Court, you must conduct committal proceedings. But you must kickstart that committal proceedings by finishing the court and the accused person with a bill of indictment which shall state in writing the charge against the accused. So if you read section 182 of the Criminal and Other Offences Procedure Act of 1960 at 30, it reads as follows, and I quote: the prosecution shall furnish the court and the accused with a bill of indictment which shall state in writing the charge against the accused, and a summary of evidence which shall comprise a list of witnesses who the prosecution proposes to call at the trial, and a summary of the evidence to be given by each witness, and the list of the documents and things it proposes to put in evidence at the trial. So this bill of indictment must be furnished by the prosecution to both the accused and the court. And this is the import of section 182 of Act 30. So for indictable offenses, we don't have anything like charge sheets. Charge sheet is used when it's a summary trial. But if it's an indictable offense, what you serve the accused person in the court with is a bill of indictment and a summary of evidence. The bill of indictment is what will state in writing the charge against the accused person and a summary of the evidence, which shall comprise a list of the witnesses who the prosecution proposes to call at the trial. Not just the witnesses, but you must summarize the evidence that each witness is about to give. Tell us that this witness A is coming to tell us that he saw the accused person holding the one gun and firing the gun at the deceased person. Tell us that witness B is the one that after the accused committed the offense, when he was running away and blood was all over him, witness B saw the accused person in that state. Summarize every evidence that each of these witnesses is about to give. Tell us the documents that you have to put in the trial. Do you have a cloth stained with blood? Do you have a cutlass you retrieved from the accused person? Do you have a weapon you retrieved from the accused person? All of these must be contained in your summary of evidence. So take note, to kickstart the whole committal proceedings, there must first be a bill of indictment, which will state the charge against the accused person, and a summary of evidence which shall comprise a list of the witnesses who the prosecution proposes to call at the trial, and a summary of the evidence to be given by each witness, and a list of the documents and things it proposes to put in evidence at the trial. But there's a very big question we need to answer. We know in Ghana, there are times when people are prosecuted by people other than the Attorney General. Attorney General can prosecute for some offenses. I mean, they have the power by law to prosecute for all offenses. But we've seen police people to prosecuting. We've seen officers from Yoko also prosecuting. So this bill of indictments we are referring to, who signs this bill of indictments? By law, who has the power to sign the bill of indictments? The answer to this question is in section 183 of Act 30. It says that, and I read, the bill of indictment and summary of evidence shall be signed by the Attorney General or by a person authorized by the Attorney General in that behalf. End of quote. It means that the bill of indictment and summary of evidence, the law has also listed and specified the person who is supposed to sign that bill of indictment. The law says it must be the Attorney General or a person authorized by the Attorney General in that behalf. So we've seen so far that to kickstart the committal proceedings, there must first be a bill of indictment and a summary of evidence. We've seen who signs the bill of indictment and summary of evidence. Now the next thing, we already know that the committal proceedings must happen at the district courts. But I want you to know that section 185 has an interesting provision that must be complied with before you begin with the committal proceedings. Section 185 of Act 30 says that the room or place in which the proceedings are held is in accordance with clause 3 of Article 126 of the Constitution, a public place. But the court may, if it considers that the ends of justice would best be served by so doing, order that a person shall not have access to, or be, or remain in that room or place without the express permission of the court. So, generally, the place where we shall have that committal proceedings is supposed to be a place that will be in accordance with Article 126, Clause 3 of the Constitution. It's supposed to be a public place, a public hearing. But if the court deems it necessary that the ends of justice will best be served, then the court shall order that someone or a person shall not have access to that particular place unless with the express permission of the court. And so if you are a journalist and you enter the place and the court thinks that the ends of justice will be served by excluding you from the premises, they can do it if the court considers same appropriate. Now, we are aware that to kickstart the committal proceedings, you need a bill of indictment and a summary of evidence. And it must be signed by the Attorney General or a person authorized by the Attorney General. We know the kinds of offenses that are triable on indictments. We know the committal proceeding starts at the district court. But what happens at the district court the first day when the committal proceedings is supposed to begin? Now, what you must note is that when the case is called in the district court for committal proceedings to take place, the court will first have to ascertain that all the parties have been served with the bill of indictment and the summary of evidence and are also in court. So, the first day when the case is called, we have to find out whether all the parties have been served. And then also find out that they have been served with the bill of indictment and the summary of evidence. And find out whether they are also in court. And once the court ascertains this, the court shall either proceed with the preliminary hearing or shall adjourn the matter to a certain time and place for the preliminary hearing to begin. So when the court ascertains that they've all been served with the bill of indictment and summary of evidence, and they're also in court, the court can either begin with a preliminary hearing on the committal proceedings or shall adjourn the matter to a time and place for the preliminary hearing to begin. If you are adjourning, make sure that you comply with the requirements of section 186 and 169 of the Act 30. It means that if the accused person is in lawful custody, that means he's not on bail. When you're adjourning, you can't adjourn beyond 14 days. But if the accused person is on bail, then you can adjourn not beyond 30 days. So when the case is called in the district court for committal proceedings to take place, and the court ascertains that all the parties have been served with the bill of indictment and the summary of evidence, and are also in court, the court may, under such a circumstance, the court shall either proceed with the preliminary hearing because all of you are here, you've all been served, or the court shall adjourn the matter to a certain time and place for the preliminary hearing to take place. If you are adjourning, remember the requirement of section 186 and 169 of the Act 30. That if the accused person is in lawful custody, the adjournment must not be beyond 14 days. So the accused person is in lawful custody. You can't adjourn for 5 months. Why would you adjourn for 5 months when somebody is in lawful custody? The law says that 169, you shall not adjourn beyond 14 days if the accused is in lawful custody. But if the accused is on bail, you shall not adjourn beyond 30 days. So what we have done so far is that we have given the introductory remarks about what will happen before the preliminary hearing or committal proceedings will begin. When I say introductory remarks, we know that we use this only in respect of indictable offenses. We know that as for indictable offenses, the court that has the jurisdiction to try those indictable offenses is the High Court. But we know that before you begin at the High Court, Section 181 requires that first go to the district court to conduct a preliminary hearing. And we know that the preliminary hearing can only be conducted at the district court. We know that before you begin the preliminary hearing, serve the accused and the court with a copy of the bill of indictment and a summary of evidence. We also know that the bill of indictment and summary of evidence under the Act must be signed by the Attorney General or a person authorized by the Attorney General in that particular respect. We know what will happen the first day too when the case is called in the district courts. The court will first have to check, has everybody been served? If so, they may either proceed with the hearing or adjourn the matter. So when we are about to commence with the preliminary hearing, when the committal proceedings is actually beginning, what really happens at the commencement of the preliminary hearing? So let's say today we are in court and the preliminary hearing is about to begin. What transpires at that committal proceedings? So what we've done so far are more like things that happen before the actual hearing. Signing of the bill of indictment, it happens before the actual hearing. It kickstarts the process. But at the actual hearing, what indeed happens over there? Section 184 of the Act 30 is very crucial on this. Section 184 of the Act 30 provides that the prosecution may address the courts in explanation of the case against the accused. So the prosecution will have to address the courts in explaining the case they have against the accused. Let me read the expert language of Section 184 of Act 30. It reads as follows, and I quote, "The prosecution may address the court in explanation of the case against the accused. An address may be made in reply by or on behalf of the accused. The address shall not be recorded, but the accused may make a statement to be recorded under Section 187. Let me explain what is happening so far. You are the prosecution and you have brought the accused person before the district court. Tell us why you brought the person over there. So the law says the prosecution may address the court in explaining the case they have against the accused. Tell the court that the accused has been brought here because he has killed 3 people on this particular day. Tell the court why you brought the accused person over there. Whatever the prosecution says, the accused may also reply. Or the lawyer may also reply. So an address may be made in reply by or on behalf of the accused. But please take note. This address that will be made by the accused person, by the accused person's lawyer, or by the accused person, that reply to the prosecution's address, that address that will be made in reply by the accused or on behalf of the accused, that address shall not be recorded. If the accused wants to make a statement, that will be recorded. There's a statement referred to as a statutory statement. As for that statement, when the accused person makes that statement, it must be recorded. So what we mean is that at the district courts, when the committal proceedings is ongoing, before the district court or the magistrate will commit the accused person for trial at the high court, there's something called statutory statement. The district court or the magistrate will have to ask the accused whether he has anything to say in answer to the charge. He has to inform the accused that he's not obliged to say anything, but whatever he says will be written down. Please do not confuse this with the plea of the accused person. We are not asking the accused person to plead guilty or not guilty. As a matter of fact, you can't even take the plea of the accused person at the district court because that is not the court that has the jurisdiction to try the capital offense. So all you are asking the accused is whether he has anything to say. And if he has anything to say, you will have to write down that statement. And that's what we call the statutory statement. So the statutory statement has been provided for under Section 187 of the Act 30. It reads as follows, and I quote, "The court shall, before deciding whether to commit the accused for trial, address to the accused the following words or words to the like effects." And I quote. So this is what the judge will say to the accused, and I'm quoting. "Accused person, before deciding whether to commit you for trial, I wish to know if you have anything to say in answer to the charge. You are not obliged to say anything, but if you have an explanation, it may be in your interest to give it now. What you wish to say will be taken down in writing. And if you are committed to trial, it may be given in evidence. If you do not give an explanation, your failure to do so may be the subject of comment by the judge, the prosecution, or the defense. End of quote. So you see, the Act under Section 187 of Act 13 has gone at length to tell you how the judge would even speak to the accused person. It says that before deciding whether to commit you for trial, I wish to know if you have anything to say in answer to the charge. You are not obliged to say anything. But if you have an explanation, it may be in your interest to give it now. What you wish to say will be taken down in writing. You see, you are informing the accuser that as for what you are about to say over here, when you say it, it will be put down in writing. And it may be given in evidence. But if you don't give an explanation, your failure to do so may be the subject of comment by the judge, the prosecution, or the defense. So therefore, Section 187 of Act 30, Section 3 provides that the statement of the accused in answer to the charge shall be recorded in full and shall be shown or read over to the accused, who shall be at full liberty to explain or add to the statement. I want you to have at the back of your mind that if the accused person is eventually committed to trial, the punishment the accused can suffer can be the death penalty if it's the offense of murder. That is a very severe punishment. So we want to make sure that everything is a step-by-step approach, and we have given the accused every opportunity to prove his innocence. So the burden is on the prosecution to establish the guilt of the accused person, but every opportunity too should be afforded to the accused person so that everything is fair to him. So that is why you tell him over here in Section 187 that I want to take this statement from you. This statement I want to take from me. If you tell me, I shall write it down. And if I write it down, it may be given in evidence against you. So I've told you ahead of time. You can decide to speak, so I write it, or you can decide to keep quiet. And remember that all of this that you are referring to over here is what we refer to as taking the statutory statements of the accused person. The statement of the accused person shall be recorded in full and shall be shown or read over to the accused, who shall be at full liberty to explain or add to the statement. But there are interesting questions over here. The accused has spoken. And let's say the accused is even an illiterate. And you are recorded into writing. And you are giving it to the accused. How can he even read it? How will he know whether what he has said is what is actually written down? And what is the accused who is a visually impaired person and cannot read what you put over there against him? These are very critical questions because the law says that the statement of the accused in answer to the charge shall be recorded in full and shown or read over to the accused. So what are you showing to a visually impaired person? If it's somebody who can see, but it's somebody who is dumb, how do you go about that particular process? And remember, this is a criminal trial that has severe consequences. So every opportunity must be afforded to everybody. This is very crucial questions. And so, if you read Section 187, Section 3 of the Act 30, it says that the statement of the accused in answer to the charge shall be recorded in full and shall be shown or read over to the accused, who shall be at full liberty to explain or answer the statement. And I'm asking a visually impaired person, an illiterate, what are the procedures that have been put in place for them? A very instructive answer to this question I've posed I mean, obtained from the book authored by Justice Dennis Dominica J., the learned author, in his book titled Criminal Procedure and Practice in Ghana, specifically at page 313. This is what the learned author says, and I quote: The court shall then show the recorded statement of the accused, where the accused is literate in English, and in all other cases shall be read over and interpreted in the language the accused understands to the accused. Where the accused is deaf or dumb or blind, the court shall get a person who understands that particular sign language to sign to the accused person. Where the accused admits the statement as a true representation of what he has given to the court, that is when the magistrate shall certify that the statement was taken in the magistrate presence and hearing, and it's the true representation of the statement made by the accused. So when it has been shown to the accused, when it has been interpreted to him, and he agrees that what has been written down is the same thing that he told the court, then the magistrate shall certify that the statement was taken in the magistrate presence and hearing, and that it's a true representation of the statement made by the accused. And you see, that's the end of quotes from the learned author's book. So take note of that, because I pose the question that how will we be sure? We must make sure that we've afforded the accused every opportunity, even when he's deaf or blind. The learned author says that you must make sure you even get somebody who can interpret in the sign language. And when the accused admits, that is when the magistrate shall now certify it. And in section 187, subsection 4 of Act 30 provides the provision and justifications for the magistrate signing. It reads as follows, and I quote section 187, subsection 4 of Act 30. It reads as follows, and I quote, when the whole statement is made conformable to what the accused declares to be the truth, the statement shall be attested by the district magistrate, who shall certify that the statement was taken in the magistrate presence and hearing and contains accurately the whole statement made by the accused. So it's only when the accused has certified that whatever has been written down is what he has said. That is when the district magistrate must come in to now certify that this statement was made in the presence of the magistrate to his hearing and it contains accurately the statement made by the accused. Remember, I'm saying do not take this to be the plea of the accused person, because at this point we are not taking the plea of the accused person. Now, what happens if the magistrate signs? According to section 187, subsection 5, I read, the accused shall sign or attest by mark the record, and where the accused refuses, the court shall add a note of the accused refusal, and the statement may be used as if the accused had signed or attested the document. You, the accused, you made your statement. It has been read over to you. You said it's your statement. Now we are asking you to sign. You must sign it. And if you don't sign, nobody can force you. But the court shall add a note indicating that the statement was read over to you, you agreed, and when you have to sign, you refuse to sign. The court will have to put that statement on the record. Now, one question that has usually arisen is that before the accused makes the statement, is he required to be sworn, to swear the oath? Section 187, subsection 6 of Act 30 provides that a person requested to make a statement under this section is entitled to do so without being sworn. You don't need to be sworn before making a statutory statement. And what if the person refuses to make the statement? You've been told already that under section 187, subsection 7 of Act 30, it reads as follows. The failure of a person charged with an offense to make a statement under this section may be the subject of comment by the judge, the prosecution, or the defense. So if you refuse to make the statement, we can't force you, but the judge may comment on your refusal to make the statement. So this is what happens when we begin the committal proceedings. The prosecution will have to address the court. The accused has a chance to reply, but as for the reply, that one is not recorded. What is recorded is what you call the statutory statement taken pursuant to section 187 of that 30. And before you take that statutory statement, make sure that you have what? Caution the accused person that we want to take this statement from you. We may use it in evidence against you. You can decide to keep quiet, but if you say it, I'll write it down. Tell the accused person. And whatever he says, record and write it down clearly, the same way that he said it. If he wants to add, allow him to add. Interpret it to him. When he declares it to be the whole truth, then the magistrate shall now sign. If the magistrate signs, accused to, it's your time to also sign. But if you refuse to sign, no problem. The court shall only add a note that you are given the opportunity and you refuse to sign. Before making a statement, you are not required to take the oath. And also finally, if you refuse to even make the statement at all too, it may be a subject of comment by the judge. But one question that is very critical is this. If the accused makes a statement at the district court, that statutory statement taken pursuant to section 187 of the Act 30, people have usually asked that can an accused person be cross-examined on that statutory statement? If the accused person makes that statement there and then, can you begin to ask the accused person as prosecution, cross-examining him on that statutory statement? What do you think about that? Can an accused person be cross-examined on the statutory statement? The answer to this question is in section 187, subsection 2 of the Act 30. So we still do not have an answer. But what does section 187, subsection 2 say? It reads as follows, and I quote, "The court shall comply with the rules set out in the said schedule as to the taking of a statement." So we still do not have our answer. Under section 187, subsection 2 is telling us is that we should comply with the requirements set out in the said schedule as to the taking of a statement. The said schedule is one of the most important provisions about committal proceedings, and it's at the bottom of the Act. So when you scroll to the said schedule, this is what we see over there. And I'm going to read every single word in this said schedule because it is so important. This is the language of the said schedule. It reads in its heading, rules as to taking statement of accused person. Section 187, subsection 2 of Act 30. Paragraph 1. You can see the said schedule on the screen. Paragraph 1. The accused making a statement must not be cross-examined, and no question should be put to the accused about it, except for the purpose of removing ambiguity in what the accused actually said. For instance, if the accused had mentioned an hour, like 7 o'clock, if the accused had mentioned an hour without saying whether it was morning or evening, or has given a day of the week and day of the month, which do not agree, or has made it clear to what individual or what place the accused intended to refer in some part of a statement, the accused may be questioned sufficiently to clear up the points. Let me explain that. The accused is not going to be cross-examined. No question should be put to the accused person unless you want to remove some ambiguity. For example, you mentioned 7 o'clock, but you didn't tell us whether it was morning or in the evening. That way we can ask you for the purpose of removing the ambiguity. If you mention the day of a week and day of the month, he said Wednesday, for example, or he said Sunday, 20th April 2022 or 2023. Meanwhile, 20th April was actually a Friday. It wasn't a Sunday. We can ask you to clarify the point to remove the ambiguity. So, the accused person making the statement must not be cross-examined, and no question should be put to the accused about it except for the purpose of removing ambiguity in what the accused actually said. For instance, if the accused had mentioned an hour without saying whether it was morning or evening, or has given a day of the week and day of the month, which do not agree, or has not made it clear to what individual or what place the accused intended to refer in some part of his statements, the accused may be questioned sufficiently to clear up the points. Paragraph 2. The court should also refer the accused to the requirement of section 131 in relation to alibis, and if necessary, explain to the accused in simple terms the meaning of an alibi. The court should then tell the accused that if the accused answer to the charge of alibi, if the accused answer to the charge is an alibi, the accused may give a personal explanation now. Although the accused may not yet be able to name the witnesses by whom the accused proposes to prove it, giving notice of the witnesses later within the time specified in the section. Paragraph 3. Where a statement already made by the accused and intended, according to the summary of evidence, to be put in evidence at the trial of the accused, appears to the court to be inconsistent with the statement now being made, the court should draw the accused's attention to the inconsistency and advise the accused to make the correction desired in the accused's present statement. So you've given a statement to the police and they intend to put that in a summary of evidence, and it's inconsistent with the statutory statement you've now made to the court. The court must draw the accused's attention to the inconsistency and advise the accused to make the desired correction in the accused's present statement. Paragraph 4. Where in view of an explanation given by the accused in the accused statement, the court thinks it desirable that the prosecution should give further consideration of the case, the court should adjourn the proceedings for that purpose. So if the accused person gives an explanation and the court thinks that this one, it is desirable that the court should adjourn to allow the accused person some more time, the court shall adjourn for that purpose. Remember I told you the end goal of this criminal trial is a severe punishment. So we want to afford the accused every opportunity in the trial process. So this is what. So you realize that I asked the question, can the accused be cross-examined on the statutory statement? And I mentioned that the answer is in section 187, subsection 2. When we went there, we were directed to the sixth schedule. And when you go to the sixth schedule, we are told that the accused must not be cross-examined. But the only thing you can ask the accused person are questions that are geared towards removing ambiguities. For example, if you mention a day and time and you need clarity, you can ask questions. Even that place too, we are told under the sixth schedule that you must also refer the accused person to alibi. Like, explain to the accused what alibi is. And tell the accused that if he has an alibi, he should give the explanation now. Even though he may not be able to give the name of the witnesses by whom he intends to prove it, he should tell us right now that he has an alibi. So the section 1, the sixth schedule is very important. It even tells us that when the accused has already made a statement to the police, and according to the summary of evidence and what right now the accused is saying by way of the statutory statement, there's an inconsistency. Draw the accused person's attention to the inconsistency, and you may ask him to clarify it. Even when the court realizes that they have to adjourn, they will even have to adjourn for that purpose. This is so important, and so I have to even refer to a better explanation of that whole procedure in the book authored by the learned Justice Dominic Day in his book Criminal Procedure and Practice in Ghana at page 311 and 312. He explains the same procedure, and it's important that I read it to further drum home the point about the procedure the court will have to use in taking the statement of the accused person. He says as follows at page 311, continuing at page 312 of the book, and I read. I'm quoting from the words of the learned Justice Dennis Dominic J. in his book Criminal Procedure and Practice in Ghana, and I'm quoting. The court, after having heard the reply by the accused, shall proceed to take statement of the accused and shall be recorded as nearly as possible and in full. The statement of the accused assists him or her to respond to the charge preferred against him or her. The magistrate, before taking the statement of the accused, shall address the accused in the following words. Before deciding whether to commit you for trial, I wish to know if you have anything to say in answer to the charge. You are not obliged to say anything, but if you have an explanation, it may be in your own interest to give it now. What you wish to say will be taken down in writing, and if you are committed for trial, it may be given in evidence. If you do not give an explanation, your failure to do so may be the subject of comment by the judge, the prosecution, or the defense. The court shall not allow the accused to be cross-examined on the statement of the accused, except for the purpose of clearing ambiguity in what the accused has said. The court shall then refer the accused to his right of alibi, as provided in section 131 of Act 30, and explain its legal significance to the accused. If an alibi exists for the accused, he may take advantage of same and file the appropriate notices. When accused in his or her defense to the police mention alibi, but the police did not ask for particulars of it and was therefore not investigated, the court shall order the accused to provide particulars. Notice of alibi in indictable offense shall be filed prior to the sitting of the trial high court on the date to which the accused is committed to stand trial before it. Where the magistrate finds that the statement given by the accused to the police is inconsistent with the statement of the accused person given in court, the magistrate shall draw the accused's attention to the inconsistency and advise the accused to make the necessary correction in the statement of the accused person. Where the magistrate is satisfied that based on the explanation given by the accused in the statement of the accused person, it is of the opinion that the prosecution shall have a second look at the case, the court shall adjourn the proceedings for that purpose. The court shall then show the recorded statement of the accused, where the accused is literate in English, and in all other cases shall be read over and interpreted in the language the accused understands. When the accused is deaf or dumb or blind, the court shall get a person who understands that particular sign language to sign to the accused. Where the accused admits the statement as a true representation of what he has given to the court, the magistrate shall certify that the statement was taken in the magistrate's presence and hearing is a true representation of the statement made by the accused. So you see, these are all things that's end of quotes from the book. These are all things that we are complying with in respect of the statutory statements. Because when you give the statutory statement, it means that will be the status that after that one, we have decided to now commit you for trial. So after you've given the statutory statement and the court has gone through all the procedures, if the court is of the opinion that there's a case for the accused person to answer that is when the court shall commit the accused person for trial at the High Court. But if the court is of the opinion that there is no case for the accused to answer, then the court shall not discharge the accused person. And you will see this under section 184, subsection 4 of the Act 30. Now, where the court is of the opinion, I'm reading section 184, subsection 4 of the Act 30. Now, where the court is of the opinion that there's a case for the accused to answer, it shall commit the accused for trial to a court of competent jurisdiction, and this part refers to at the trial courts. And then section 184, subsection 5 of Act 30 says as follows. Where the court is of the opinion that there is no case for the accused to answer, it shall discharge the accused, but subject to clause 7 of Article 19 of the Constitution, the discharge shall not be a bar to a subsequent charge in respect of the same fact. So even at the committal stage, when the prosecutors bring the bill of indictment, summary of evidence, they give their address, accused gives his reply, accused gives the statutory statement, the district court at that stage can look at everything and say that I don't think a case has been made out against the accused person to commit the accused for trial. In that case, I shall discharge the accused person. But if the court is of the opinion that there's a case for the accused to answer, that one, the court shall commit the accused for trial to a court of competent jurisdiction. So even at the committal proceedings too, the case can end. If the district court is of the opinion that there's no case for the accused to answer, it shall decide the accused person. But the question is this: how would the district courts determine whether the accused should be committed to trial or not? You're the district court. You're not the trial court. So what is going to guide you in determining whether you're going to commit the accused person for trial or not? What are you even looking at? Because you're not the trial court. You don't even have jurisdiction to try the offense. So how are you the one making a decision on whether to commit the accused person for trial? What do you consider? Because at that point, you're not even taking any evidence. And this is a question that we have people asking lots of the time. How will the district court determine? Because section 184, subsection 4 says that where the court is of the opinion that there's a case for the accused to answer, it shall commit the accused for trial to a court of competent jurisdiction. And if the court is of the opinion that there's no case for the accused to answer, it shall decide the accused. The question is, how will the court determine whether to commit the accused person for trial or not? What should be the guiding principles? The Act doesn't give us the answer. But when we turn to the book authored by the learned Dennis Dominic J, in his book titled Criminal Procedure and Practice in Ghana, which I've already said is a very good book, and you look at page 313, it gives us a lot of assistance in how the court will determine whether to commit the accused person for trial or not. And this is what the learned author says, and I quote at page 313 of his book. Where the court is of the opinion that there is a cause for the accused to appear before the High Court, the court shall commit the accused to stand trial before the trial High Court. The summary of evidence served on the magistrate to conduct the preliminary hearing is not the evidence of the accused and the witnesses. And a magistrate's main duty is to examine it to ascertain whether the ingredients of the offense charged can be proved based on the summary of evidence filed in the court. On that score, where from the summary of evidence there's evidence on each of the ingredients of the offense, it is bound to commit the accused to stand trial. Let me comment on this. The role of the judge is to examine the summary of evidence. Remember, we mentioned that we kickstart these proceedings with the bill of indictment and summary of evidence. So the judge is to look at the bill of indictment, look at the summary of evidence, and ascertain whether the ingredients of the offense charged can be proved based on the summary of evidence filed in the court. So if it's an offense of rape, and we look at all the elements of rape, and we look at the evidence you're about to give, and it can enable the court to convict on that, then that one, it will have to commit the accused person to stand trial. But what if, for example, you charge the person for murder, and at the district court, you've not been able to even show that there's a dead body? All the witnesses, none of them are showing that they've seen any dead body. How would the court even know whether to commit the person for trial or not? In that instance, one of the essential elements of murder has not been established. Or you want an autopsy report that will show the cause of death, linking it to the accused person, and you don't have it. So if you read the same book at page 314, this one the learned author says, and I quote, "The magistrate does not have the right to discuss the issue of credibility at the committal stage, as there will be no sworn evidence to determine whether a witness is credible or not. The magistrate's role at the committal stage is totally different from submission of no case, which is made after the close of the prosecution's case. The test for the magistrate is whether, looking at the summary of evidence, there is evidence on each of the ingredients of the offense charged. And if there is, the accused shall be committed. And if there is no such evidence, the court shall discharge the accused." I'll read that portion twice. The test for the magistrate is whether, looking at the summary of evidence, there is evidence on each of the ingredients of the offense charged, and if there is, the accused shall be committed. And if there is no such evidence, the court shall discharge the accused person. And so, that is the import of section 184, subsection 4 of Act 30. So when you read section 184, subsection 4, we say that where the court is of the opinion that is a case for the accused to answer, it shall commit the accused for trial to a court of competent jurisdiction. In this part refers to the trial court. It is telling you that the court has a role to play in determining whether to commit an accused person for trial or not. And we've been told the guidelines by Sir Dennis Dominic J. So the test for the magistrates is whether, looking at the summary of evidence, there's evidence on each of the ingredients of the offense charge. And if there is, the accused shall be committed. And if there's no such evidence, the court shall discharge the accused person. So when you read section 184 and you want to find out the guiding principles that will guide the court to know whether to commit an accused for trial or not, listen to the words of Sir Dennis Dominic J. in his book Criminal Procedure and Practice in Ghana. Now, when the court decides to commit an accused person for trial, what must the court still do? Section 188, subsection 1 says that the court, on committing the accused for trial, shall ask the accused whether the accused desires to call witnesses at the trial. So now the court has decided to commit the accused for trial. If you are deciding to commit the accused for trial, please ask the accused, do you have witnesses you intend to call? If the accused desires to call witnesses, section 188, subsection 2 of Act 30 reads as follows: that where the accused states the desire to call witnesses, the court shall cause to be taken down in writing the name, address, and any other necessary particulars of each witness. Where the accused states the desire to call the witnesses, the court shall cause to be taken down in writing the name, address, and any other necessary particulars of each witness. But there's one question I want to ask, and it comes up very often. If you're an accused person, you have been accused of murder. Meanwhile, there are people that you know who are witnesses that can testify that you are not the one who fired the gun. But all of them are not ready to come and testify for you because they don't even like you already. So as for them, they have told you that they are happy that they frame charges against you and they will make sure that you are imprisoned. But the people are aware that you're not the one who fired the gun. They are aware. And these are people that you want to call, but they are not in good terms with you, so they don't want to come and assist you to testify. What can you do as an accused person? Is there any way you can force them to come and testify? The answer is yes. The law has far-reaching consequences. The law says that even if that witness is in court, tell the court that this person here, I want to call him as a witness. And the court can even tell the person to sign a recognizance and let somebody to be a surety for that person that that person would appear to the court to testify. So just like Bill, if I say that I want you to testify for me because you have some information, the court can tell you that, okay, stand up. This man says you will be testifying for him. So the case is going to be held in court. We want to make sure that we will guarantee your attendance. So get somebody to stand as a surety for you, and so that the person will guarantee that you will appear to stand before the court to testify. And if you refuse to even let someone stand as surety for you, the court can order you to go into prison, so that you stay there until the time that you give the evidence before they allow you to go back home. Yes, you are in court. They say that come and testify, and you don't testify. The court can commit you to prison. Stay there, come and testify. Let me show you the provisions in the Act. Look at section 188, section 3, 4, and 5. 188, section 3 over 30 reads as follows. Where a witness is present in court, the court may bind the witness by a recognizance, with or without a surety, to appear at the trial to give evidence. Subsection 4. The court shall inform the accused of the accused's right to require the attendance at the trial of a witness and of the steps to be taken by the accused for the purpose of enforcing the attendance. Subsection 5. The accused may give notice to the district court at any time before the date to which the accused has been committed for trial, and at any time after that to the registrar of the trial court of the desire of a witness to attend the trial, and the court or registrar shall call a summons to be sent on the witness for attendance at the trial. So the accused can also notify the registrar that I want Kofi Mensah to come and testify for me, and the court can issue a summons to be sent on that person to come and testify. And look at the consequence. Section 189. Where a witness refuses to enter into a recognizance, the court may commit the witness to prison or into the custody of any officer of the court, there to remain until after the trial, unless in the meantime the witness enters into a recognizance. Look at how far the law is even going to ensure that we afford every opportunity to the accused person. The accused person is in court. He says that he wants someone to testify for him. And if you're in court, he can just point you to the judge. The judge will call you and tell you to enter into a recognizance. If you refuse, then they can order you to be committed to prison. Stay there until you testify and they release you. If the person is not in court, the court is supposed to inform the accused person that you can give their names to the registrar. The registrar shall send them with the summons. And if they refuse to come, then they shall be put into prison, there to remain until after the trial. If they come and refuse to enter into the recognizance. Look at section 189, section 1. Where a witness refuses to enter into a recognizance, the court may commit the witness to prison or into the custody of any officer of the court, there to remain until after the trial, unless in the meantime the witness enters into a recognizance. This is a very critical step. And this is what the learned author said in his Dominica J. in his book Criminal Procedure and Practice in Ghana. At page 315 says, and I've told you it's a very critical book, that if we get it will simplify criminal procedure for you in Ghana. This is what he said at page 315. The courts, on committing the accused to stand trial, shall inquire from the accused if he has witnesses to testify on his behalf before the trial courts. Again, the courts, on committing the accused to stand trial, shall inquire from the accused if he has witnesses to testify on his behalf before the trial high courts. Where the accused answers in the affirmative, the court shall record the name, address, and any other necessary particulars of every witness mentioned. When a person who is mentioned by the accused is in the court may bind the witness by recognizance, with or without surety, to appear at the trial high court to give evidence. The court shall then inform the accused of the accused's rights to enforce the attendance of the witness he intends to call at the trial. The court shall inform the accused to state the names of the witnesses to the trial high court judge to summon them to appear before it to testify on behalf of the accused. The court shall further enforce the rights available to the accused to compel the attendance of witnesses of that accused, including giving a notice to the appropriate registrar to serve summons on the witness. And if the witness fails to appear, the court shall issue a warrant to cause the arrest of the witness. Again, and if the witness fails to appear, the court shall issue a warrant to cause the arrest of the witness. Then at page 316, the learned author continues. While the witness is arrested, the higher court may keep the witness in custody until the completion of the evidence of the witness. In a case where the witness comes to give false evidence, the witness may be committed for perjury. Let me pause there before I continue. We want you to come and give evidence for the accused. When you come, your job is to speak the truth. So you can't say that because we are going to lock you up in prison because of the accused. If you come into the box, you come and lie against him so that you spoil his case. If you come and lie and give false evidence, the witness may be committed for perjury. So when you come, you must still speak the truth. Learned author continues on that same page. When a person in court is named by an accused as a witness, the accused intends to call, and the person fails to enter into recognizance, the court may commit that person to prison or into custody of any officer of the court, and the person shall remain there until the person has testified and has been discharged by the court, or until any time the person enters into a recognizance. Where a person is in court is named by an accused as a witness, the accused intends to call, and the person fails to enter into recognizance, the court may commit that person to prison or into custody of any officer of the court, and the person shall remain there until the person has testified and has been discharged by the court, or until any time the person enters into a recognizance. In the case where the accused is acquitted afterwards by the High Court for want of sufficient evidence or other cause, the court shall order for the discharge and release of the person imprisoned for refusing to enter into a recognizance. In other words, if you are in prison because you refuse to enter into a recognizance and now the case has even ended, that case has been discharged, then you too will have to come and release you. This is showing the extent to which the law is going to enforce the attendance of witnesses. Because section 188(1) says that the court on committing the accused for trial shall ask the accused whether the accused desires to call any witness. So now you know. If he desires to call a witness, tell the court, name them. If they don't come, a warrant shall be issued for their arrest. If they come, we'll require them to enter into a recognizance. If they refuse, we'll put them in prison. We'll let them stay there until they come and testify for you. When they finish testifying, we'll let them go home. So section 188(1) says that the court on committing the accused for trial shall ask the accused whether the accused desires to call witnesses at the trial. And this is the extent to which the court will go to ensure that we are able to bring those witnesses to enable the accused prove his case. To the extent that even if you're the witness, you refuse to enter into a recognizance, we can even let you go into prison. Stay there until we are able to make you testify. So that was section 188, telling us what the court will do before it will commit the accused person for trial. So after committing the accused person for trial, what then must the court do? Because now you have taken the witnesses that the accused intends to call. what do you do next? Section 190 of the Act reads as follows. The order of the district court committing an accused for trial shall name the day, time, and place at which the accused is to appear before the trial court in answer to the indictment. The order of the district court committing an accused for trial shall name the day, time, and place at which the accused is to appear before the trial court in answer to the indictment. The day named for the accused person to appear before the trial court shall not be more than 1 month after the date of committal. So now that we have decided to commit you for trial, we must tell you that we are committing for trial at the High Court Criminal Court 2 at this particular time, to go there and answer to the trial on indictment. But we must not give a date that will be too far away. After committing for trial, Section 190 Section 2 says that then the day named for the accused to appear before the trial court shall not be more than 1 month after the date of committal. But the question is, what if you fail to the judge failed to comply with Section 191 and 192? Let's say you didn't give them the day, time, and place properly, or you didn't comply with the 1 month adjournment. Section 190 Section 3 says that a committal for trial shall not be invalidated by reason only of a failure to comply with subsection 1 and 2. We will not say that the whole committal proceedings is a nullity because the judge failed to comply with Section 190 Section 1, which says that he must take the day, time, and place where the accused is supposed to appear before for the trial. If he failed to comply with that, it should not nullify the whole committal proceedings. So at this point, the judge is committing you for trial, the order of committal. The order of committal must name the day, time, and place at which the accused is to appear before the trial. But it should not be more than a month from the time the accused is committed for trial. And at that time, the district court shall either admit the accused person to bail. We can look at Section 190, Section 4 of Act 30. The district court shall admit the accused to bail or send the accused to prison for safekeeping until the day so named. Of course, we adjourn the case for you to appear for trial. So what do? Do we keep him in custody or we let you? So you can either admit you to bail or adjourn the case for that particular purpose. There is a controversy over here, which will be discussed later, about whether the district court has the power to grant bail, even though the district court does not have the power to try an indictable offense. There is an intellectual discourse around this particular section, which will be discussed in another lecture. But after the order of committal, what happens next? On the Section 193 provides the answer. On the committal for trial, the bill of indictment, the summary of evidence, or a recorded statement of the accused, the answer of the accused respecting the court, before which the accused desires to be tried, the recognizance of the witnesses, and of the recognizance of the bill, and any other document and things which have been delivered into the custody of the district court, they shall be transmitted in proper time to the trial court. It's as simple as that. The district court, you are not the one that is going to try the offense. So everything that has come into your custody, please forward everything to the court and give an authenticated copy to the Attorney General. So Section 193, an authenticated copy of the document referred to in subsection 1 shall be transmitted to the Attorney General. So after the order of committal is made under Section 190, it shall name the day and place that they are going to conduct the trial. And it must not be more than 1 month after the date of committal. And then that after the order of committal is made, it means the district court, you are done with your work. You don't have anything more to do because you said you are committing the accused person for trial at the High Court. What more do you have to do? So everything over there. That's why Section 193 says that on the committal for trial, the bill of indictment, summary of evidence, a recorded statement of the accused, answer of the accused, the recognizances, witnesses, any other documents, and things that have been delivered into the custody of the district court shall be transmitted in proper time to the High Court. Because district court, you are done with your work. And then an authenticated copy too shall be transmitted to the Attorney General. So these are elaborate processes we've gone through for committal proceedings. It looks very simple, but there are details of each of the stages that you must go through. And it is important for legal practitioners to know each of these details. But the question is, what if errors are committed with respect to these elaborate proceedings? Can the errors invalidate the whole committal proceedings? You are supposed to comply with something that we've gone through now that you fail to comply with. What will be the effects of failing to comply with it? Section 193A/30 provides an answer, and that's what it says. Although there is a contrary provision of this act, any error, omission, or irregularity in respect of a matter specified in section 181 to 193 during the preliminary hearing before a district court of the case of an accused person shall not invalidate the committal for trial unless a district magistrate or justice is of the opinion that the error, omission, or irregularity is likely to occasion a substantial miscarriage of justice. End of quote. So it's not automatic that once you commit an error, it will invalidate proceedings. But there are some errors that those ones, it can affect the committal proceedings. Because it says that unless a district magistrate or justice is of the opinion that the error, omission, or irregularity is likely to occasion a substantial miscarriage of justice. If it's going to occasion a substantial miscarriage of justice to the accused person, that's one. You must invalidate the proceedings. So the errors will not automatically invalidate the proceedings. It will depend on whether the error is going to occasion a substantial miscarriage of justice. And this is how the learned author said in Mr. J, quotes it in his book, Criminal Procedure and Practice in Ghana at page 319. And I quote, no omission, error, or irregularity that occurs in the preliminary hearing specified in sections 183 to 193 shall invalidate the committal for trial unless the magistrate or the high court judge is of the opinion that the error, omission, or irregularity is likely to occasion substantial miscarriage of justice. The general principle of law is that a criminal appeal succeeds on grounds that it has occasioned a substantial miscarriage of justice. And therefore, any error, omission, or irregularity in preliminary hearing that is likely to occasion substantial miscarriage of justice shall be set aside by the court or the trial high court to prevent a valid appeal to be lodged against the proceedings at the end of the trial. End of quote. What the learned justice is saying is that it is a rule of law that errors or an irregularity that has occasioned a substantial miscarriage of justice can be a ground for you to appeal against a decision. So if you are a judge and you see an error that can occasion a substantial miscarriage of justice, why do you want the case to go all the way to the end when you know someone can use that one as a basis to appeal and quash the whole thing? So if it's an error that can occasion a substantial miscarriage of justice, that's one. You must make sure you set it aside and begin the whole process afresh or to correct it. But if it's an error that will not occasion a substantial miscarriage of justice, that's when the court may still proceed. This is where we can say that we have come to the end of committal proceedings. And I know we've said a lot, so what I'll do now is to summarize all the stages into respective paragraphs to let you know what we've done so far in this lecture. So by way of summary, this is what we've been doing so far, and then you can take notes because I've summarized each of the points and the steps so far. First, number one, that a preliminary hearing shall take place before a district court for a person charged with an offense which is not being tried summarily. Number two, the prosecution shall furnish the district court and the accused person with a copy of each of the bill of indictment and summary of evidence. Now, this bill of indictment and summary of evidence shall be signed by the Attorney General or an authorized person on his behalf. On the date of the hearing, that's number 4. On the date of the hearing, the magistrate shall ask the accused if he has been served with a copy of this bill of indictment and summary of evidence. In addition to that, at number 5, the magistrate shall in addition ascertain by making sure that there is proof of service on the docket to that effect. Once the magistrate ascertains that there is proof of service, they will go to number 6, that the prosecution may now address the courts in explaining the case by giving brief facts. After the prosecution has given their brief facts, then the accused may also give a reply, either to the accused personally or through the accused person's lawyer. The address and the reply of both the prosecution and accused are not to be recorded. Number 9, the magistrate must ask the accused whether he has anything to say before committing the accused person for trial. Number 10, the statement given by the accused is what we call the statutory statement, which we dealt with into detail. And number 11, the accused is not sworn before he makes the statutory statement. You don't swear an oath before making the statutory statement. Number 12, the statement shall be recorded verbatim. What the accused person says is what must be recorded. Number 13, if the statement or any part of the statement is inconsistent with any of his statements given by the accused to the police, the magistrate shall give the accused the opportunity to explain why the difference in explanation. The explanation, if any two, shall be recorded verbatim by the magistrate. Then after that one, number 14, the statement made by the accused shall be sworn or read over to the accused, and the accused shall have the full liberty to explain or add to the statements. When the whole statement is declared by the accused to be the truth, the magistrate shall attest to it by certifying that the statement was made in the presence and hearing of the magistrate and that the statement is accurate. Then number 16, the accused shall also be required to make a sign. Then number 17, if the accused refuses to make a sign, the magistrate shall add a note to that effect. Number 18, the magistrate must, if necessary, explain to the accused in simple terms the meaning of alibi. In explaining alibi to the accused, the magistrate must inform the accused that he can, in his explanation, that although he may not be able to immediately name the witnesses by whom he proposes to prove the alibi, in other words, he can just mention that he has a defense of alibi, even though he doesn't have the names and addresses readily available. In other words, the accused is informed that he can give notice of the witnesses later. Number 20, after the committal order, the magistrate will be asked, after the committal order, the magistrate will ask the accused whether he desires to call witnesses at the trial. The magistrate will ask the accused whether he desires to call witnesses at the trial. If the answer is an affirmative, the magistrate shall take down the names and addresses of any particulars of such witnesses. That's number 21. Then 22, the court shall then inform the accused of his right to require the attendance at the trial of any witness. The court shall inform the accused of his right to require the attendance at the trial of any witness. Then 23, the court shall also inform the accused of steps that he must take for the purpose of ensuring the attendance of such witnesses. 24, where the witness is in court, the court may bind the witness by a recognizance, with or without a surety, to give evidence. 25, where a witness who refuses to enter into a recognizance. A witness who refuses to enter into a recognizance may be committed to prison or into the custody of any officer of the court, there to remain until after the trial, unless in the meantime the witness enters into a recognizance. 26, the order of committal shall name a date, time, and place at which the accused is to appear before the trial high courts to face trial, and the date shall not be more than 1 month from the date after the committal. 27, the magistrate shall admit the accused to bail or remand him in custody to appear before the trial court on the given date. Remember, I mentioned over here that there's a controversy over here that will be resolved in another lecture later about whether the district court can grant bail. Then 28, after the committal, the accused, the committal process, including the statutory statements and intended exhibits delivered into the custody of the district court, are all transmitted to the trial high courts. Remember, we said that the district court is finished with their work. So what more are they doing? Then everything is supposed to be transmitted to the trial high courts. 29, authenticated copies of all the processes shall also be given to the Attorney General, because they will definitely have to prosecute the case. So now everything has been given to the trial court and Attorney General. What more is there? Errors. If there are any errors or irregularities, they shall not render the committal invalid. Unless, of course, you remember what we said, that they can occasion a substantial miscarriage of justice. This is the end of our lecture on the overview of committal proceedings in Ghana. And remember that this is the first step we'll take before we begin a trial on indictment by judge and jury. And then for our next lecture, we'll be trial on indictment by judge and jury, where we'll go through all the stages from beginning to the end. Thank you.